Okay, everyone, it's March 20th, 2024. Auspicious time. We're just going on raising world consciousness and helping more and more people move out of slavery into freedom, freedom philosophy, freedom technology. We have today our good friends Randall Hillner, the writer of the trusts, and Will Barney, a former banker who is using them and is helping to consult on them and provide a lot of knowledge for them. So we are Brilliance and Commerce, a project of Verite, which means the truth in French, and House of Freedom International Natural Law Trust is our main topic today. We are members of the Worldwide Charter for Fair International Commerce. If you haven't already seen that on the website, please take a look. Today's March 20th. Our next trust webinar with Randall Hillner will be May 15th, 2024, so you can put that on your calendar. And the recording on YouTube of these videos you can find on our URL, www.brilliance-videos.com. That is what leads to our YouTube channel, and you can see all our videos there. For those who need it, our phone number is 360-200-7521. And I'm Tonson Fairmont. I'm the founder. I've been very privileged to work with Randall for ever since the 90s. And we've had a long journey of helping more and more people. And so far, knock on wood, not a single problem, 100% success rate with the trusts. Randall's head of our trust department. He has several proteges studying with him. So if you ever can't reach him, if you're a trust client, you will have the contact information for Dominique and Laurel. And so Dominique here is pictured, and she has a great background both in statutory law and in common law, and understands accounting and is writing a trust accounting book. And so she's available. She taught the trust study group for a while, and those recordings are available. Laurel White also works with Randall. She's available for consultation and assists with nominee grantor, maybe trustee, depending on, she accepts trustee appointments case by case. We really recommend that the client, you, the creator of the trust, be your own managing trustee. But Laurel does provide a variety of services and auxiliary to that. Today's topic, beware the Ides of March. Commerce, equity, and trusts. The Cestui v, he who lives, Cestui use for his use, and Cestui trust, he who benefits. So please, Randall, illuminate us.
Thank you very much. Yes, you illuminated us already. So what we had, we talked about this a month ago. We ended our session with the difference between a natural law trust and the corporation and the advantages of one over the other, and maybe some disadvantages or some liabilities that exist in a corporation that don't exist in our natural law trust. What we have to remember is when we're using this trust to go into commerce, into the equity, into the public domain, we want to have a safe vehicle where we can use it, and we're not so confined with the potential, with the limits of a corporation. And I'll explain those in a little bit. We're going to actually have a chart, and we'll show those differences between the natural law trust and the corporation, and how the natural law trust, being a unalienable right to contract, your unalienable right of contract is held one of the highest prestigious elements of this whole United States of America and our Constitution. So we have to really get that what we're doing in the corporate, getting out of the corporate structure and into natural law trust and pure equity and pure contracts is where we want to go. So let me read a little bit and I'll just give a hint. So there's a particular thing, and I hope Tonson's included a link to it on their website. But basically, this is from a gentleman named Weiss, and he has a concise trustee handbook. It's very productive. It's a little more, it's if you really want to study the process, then do that. But if it's not, it's a little bit intense, and you can always get it, and we can feed it off each other, and we can talk about it that way. So let me say the decision of the court was the decision of the United States Supreme Court holding that the express trust and natural law trust are not subject to the federal excise tax on corporations. Okay, right there is a difference between the corporate entity having to have a tax and the natural law trust not having to have one. It's been emphasized this method of conducting business as comparing with corporations. The best legal talent was soon impressed into the service of devising a means of offering the usual advantages belonging to a corporation without the authority of any legislative act. Okay, so here's the beginning of the difference. We have a contract between two people with the benefit of a third person, and we have a corporation that has to go on only what the government will give them as far as ability to act, how they have their privileges and how they're taxed, et cetera. And it's all restricted compared to having a natural law trust. So the method of placing the property into the hands of trustees who held the legal and lawful title and issued certificates similar to shares, but they're not, gives us a Cestui trust, which is for he who lives, he who benefits. So creator gets together, the grantor gets together, he decides on trustees, two trustees, co-trustees, and the benefit is for Cestui trust, the beneficiary. And that's the whole deal. Whereas with a corporation, it's all mixed up. And so when we get into that, the next slide, I hope it's going to show how the differences are. So before we get there, I just want to say, okay, so it includes the interest owned by each possessed nearly all the advantages desired. This excluded the use of limited liability companies, joint stock up associations, and co-partnerships, which are organized under enabling statutes. That's the corporate structure, which merely enlarge the privileges possessed common law. They are therefore subject to state regulations, which may be equally burdensome to those imposed on corporations. So we have to get out of the corporate structure and get into our ability to have a natural law trust, a natural law contract. You have a right to contract for anything in the world, and so does the trust. Okay, let's get into that slide, see what happens. Okay, here we go. So we're going to try to understand a little bit about commerce, because commerce is what we are going into whenever we go out our front door and we go into the public realm. We're dealing basically in commerce. One is your automobile, one is going to the store, to the bank. All of that is dealing with commerce. Now you can deal with it in your own pocket, or you can deal with it in the pocket of the trustee, the trust, so to speak. And what it does is it takes away that a liability factor that you have by owning it in your own pocket. If you have it in your own pocket, if you possess it and you hurt somebody, or if there's a breach in contract, then property can be gone after. So, but if we take it and we take it out of our own pocket and we put it into trust, and we've chosen the trustees in an appropriate way, and we have the beneficiaries in place, then we have a way to separate you from the asset. And that protects you and that protects the asset. And so let's say you have a business and your business creates a liability or tort. And if you own the business, then they're going to come get you and your house and anything involved with your property. Whereas if the business itself is put into trust, then it's solely there by itself. And any tort can only go after what's in the trust. So the idea is to is to create a lot of separation between the trust and your property. So again, we're emphasizing the fact that the trust can engage in any manner of trade or business. It's really open. Anything that I can do, you can do, the trust can do. As long as it's not illegal and it's within the trust documents, then you're good to go. And what we do in the trust document is we spell out, we say you don't have any general powers, but these are the specific powers that the trustees have. And so they're defined and it's clearly amenable to the whole process. And if there's ever an issue, the court is directed to look at the contract rather than what the laws are. They have to look at your trust contract to see what the ability of the trustees was or were, and then decide on those merits, not on the merits of statutory law. So that's the uniqueness about the trust over a corporation. In some places, countries are not necessarily recognizing our incredible trust yet, and so they make it a hard time. We do have amazing results with some bankers who just, like Tanzan said, just invited him right in, didn't have to show paperwork. And other people balk at it because they're just not used to what a trust does and how it works and how it really relieves the banker also of liability, because in the trust document itself, there's a particular section that says any process with the bank is not responsible for anything that the trust does. And so
Uh,
the bank is off the hook.
yeah, that's point number 7 in the trust certification minute.
Right. And why do we want to do this? Because our trust works under equity law. And equity law is if you say something or do something, it needs to be clean and you need to perform on the contract. And so if you just do common law, the common law court would say, well, okay, there's a wrong here, but something was missing because the court could not say, well, you need to compensate this gentleman for that. So what they did is common law went into what's called an equity law, equity meaning you need to perform on the contract. You can't just say, oh, I did it wrong and I'm sorry. You need to be compelled to perform. And that's what the equity clause does. And that's what equity does for the trust. And that's what equity does for the courts. It makes them come up and stand up and compel performance if there's a tort, if there's a wrong somewhere, then it needs to be corrected. And so what happens is the trust work we've done over the last 30, 40 years, my mentor from the 60s in California, there was never an issue with the trust document itself. It was always with the performance of either the trustees or the beneficiaries, and so it wasn't very, very seldom has it been the fact that the trust is malfunctioning. And within the trust document, we also have a section that says if anything in the trust fails, it doesn't negate the whole trust. It only means that you have to perfect or transcribe the wrong that exists there so that it can be cleaned up and the trust runs accordingly again, owns up to its mistakes if it has made, but it's also willing to go out there and compel performance on somebody else. If the trust goes out and contracts with somebody and they don't perform, then you have the right as a trustee. In fact, you have the duty as a trustee to go and sue that third party for breach of contract. So be very aware is how that works. Breach of contract works two ways. Works one is if somebody else, third party breaks the contract, then you can go ask for a correction. And if you do it, then you be ready for having to correct the performance yourself. So it's a very, very powerful process that's being promoted. And Dominique has been really good. She's been really pushing me on equity. She's involved pretty much with this group that she's working with, and I'm ready to go as well. I've just been really busy. And so she's really bringing points to add to what we have as a new trust document. It's really, really, really good, really powerful. And I just found a point. I was going in doing some more research and realized that we talk about, oh, the common law came from England, and the trust came from England, but it actually, when you go back far enough, it's actually in Roman civil law. All the very wealthy people in Rome and Roman territory all had their estates in trust because they knew that if they had it in trust, it wouldn't go into probate and the government wouldn't get it. And then that's what happened is a Roman law, and then the church started to take over, and the church started to get used to be the trustee for all the people that were going away. And so the trust created tremendous, I mean, the church created all this power. And so then the structure came in, they took it away from the state. And so now the state has to come back and say, wait a minute, separation of church and state is fine. Separate the church belongs to the church. Whatever the church does belongs to them. Whatever the state does belongs to them. Where the trust comes in, as it can be in either one of those places. You can use this trust as a part of your church or your mission statement. If you have a mission or a ministry, you can use the trust to work your ministry. If you're working within a state, you use the trust to bill and invoice any kind of work that you do on a contract. It's very, very powerful. And
On
it
that
really
point,
does separate.
Randall, may I comment that if anyone in the audience knows any church ministers or heads of churches, you need to tell them about the natural law trust. Because if they have their church in a 501(c), the government can limit what they can say from the pulpit.
Correct.
Whereas in a natural law trust, they have no such restriction. They can say what they want because no state can remove the trust. They can remove the 501(c). They can remove their tax exemption, but they can't remove the trust exception because it's an exception. You can't be removed.
Right. That's very good. And that's really a unique process. And so we have to hold on to that it's solid. And so we can depend on that. And so out of that church and state, what do we have? We have the Vatican Bank, the Pope rules the banking world. We have the Rothschild banks and the Federal Reserve and the US government. They're all corporations and they're all a fiction. So what we're going to do with the natural law trust is bring it back to the person, to the humanness of how we want to work in our world. What do you want to do to create any wrongs that you might be able to work your endeavors on? And how do we correct the fact that certain corporations control all the manifestations in the physical world? And we can use our natural law trust to be able to negotiate within that realm, within those circles. So that's the uniqueness of the natural law trust. Okay, fictions. Yes, when you get anything from the government and it's got your name on it, you usually see that it's all in capital letters. Why is that? Well, because you're a fiction according to the government. So one of the things that we want to do with the natural law trust and BIC is to get you back into that you're a human, that your name is spelled with upper and lowercase letters, and that you're not a corporate fiction. Okay, any questions on that can come up at the end here. Traveling in the universe. I love it. Or get lost in this one, Tanzan. Okay, so you're allowed to do anything that anybody in this picture can do. So that's all it's doing business is you're permitted to do anything, but you must tell anybody that's working with your contract that it is a trust and that you're a trustee or you have a capacity to entertain this contract. So be very clear. So the trust is obligated for its obligations, and the trustee can bind the trust to obligations. So the trustees must be under perform. In other words, they have to perform under a prudent manner rule. In other words, the prudence of a man dictates his ability to operate in the world and out of the world. And so what we want to do is make sure that trust knows what its fiduciary responsibilities are. The trustees know that, and all disclosure is taken care of, and that everything is upfront, and that there's a paper trail, a good paper trail for all the work that you do with between the trust and any contract that you fulfill. Okay. Next, please. So how do we limit liability? Okay, so what we talk about, the whole essence of what we do in our program here at BSE and the Natural Law Trust, we want to create a document that separates you from your assets in a lawful legal manner. And so that you have benefit for you or for your family or for humanitarian projects. A client today is significant sum of money coming in all to the humanitarian projects with minimal going to his family, just enough to take care of his needs, and the rest goes to his projects. And so this is how you declare it in the paperwork that we do. It's all laid out. There's so many different sections that say why did this gets organized, who organized it, who's this person, what does this person do, what is his roles, etc. If you have a trust document and you haven't read it for a while, please do. If you have read it and you have questions about it, please write questions down and email them to me. I'm really open to that. That's my best teaching modality, is responding to questions. So please do that. Any questions, come my way, especially if you're a client. Signature means you're basically, when you come into the trust as a trustee or as a manager, whatever capacity, is you clearly define when you're signing checks, what are you signing as? Are you signing as you? If you're signing as you, that could get you in trouble if you're signing trustee checks, trust checks. So make sure when you're a trustee or when you're a third party affiliate, when you're signing any checks for the trust, it's as a role: trustee, beneficiary, settler. It's all there. And just make sure that that you get used to signing your name as a role model. Trust abstract, what we do is we take about 20 pages, push them aside. That's part of the initial indenture, and then the 10 pages of an abstract. That's usually what you take to the bank. As Tanzan said, he went to a bank and they didn't ask for anything. And sometimes they want only the abstract, and sometimes they want a copy of the whole trust. And it's okay to give them a copy of the trust if that's what's important. If that will allow them to open a bank account for you, then say, okay, here, I have a copy. Just make sure that you take any private minutes out. The minutes are always private. They belong to you. In fact, if you're a trustee, you're under a fiduciary capacity to make sure that those are kept private. Then we have memorandum of trust minutes. It's where we have those defining, we're going to start to define the essence of what the trust is into 2 or 3 pages rather than 30 or 40 pages. So we have a memorandum of trust. It points out who's doing what, who the trustees are, the names, what it's going to do, what the vision is, what it intends to do, etc. Then you have instructions on how to get a EIN number or an ID number if you're in Europe or out of the US. You have a trust certification minute, which really is the most important because it certifies, the trustees certify under penalties of perjury and notary that this is a true certification of what the trust is. And the banks can't argue with that. You also have a banking resolution minute. That resolution minute defines, it basically is between you and the bank. You're going to sign a contract with the bank, say this bank at this branch and this manager and I are going to entertain this account here, and that's it. And there you go. So you have limited liability. How do we get there? We separate our assets. We take them out of our pocket and put them in the pocket of a trust. You learn how to sign as trustee. You learn how to present an abstract. You learn what the abstract is. If you don't want to do the 30 pages of the trust document, please at least read the trust abstract and get used to understanding it's minimal. Trust certification is really vital. Banking resolution, the most important are the memorandum and the trust certification. Okay. That's that side. Anything else? So now we're going to trust. We're going to transfer. How do we do that? So we have a number of schedules. And what we do is we start with the schedules. We have a Schedule A, which is for personal property. So here's where we start to list our gold, silver assets, jewelry, gems, paintings, anything of personal value to us, expensive, whatever is valuable. Now, I'm not talking about a valuable car or a valuable airplane. If you have those, you need to not put them in with your personal assets, because planes and trains and automobiles are all liabilities. So please do not put an automobile in with your assets. If you have a valuable automobile or a plane, please put it in its own trust. You'll have a much more definitive process in hand. And you have to, the trustees have to act in good faith that they're actually doing the correct thing, that they're doing it for the reasons that the grantor wanted, that the vision of the trust is carried out through the process of the trustees and what they do, and everything that goes on in between. And the guidelines, what you get in the document are documentation of the evidence of transfer. So you put the Schedule A goes in, and that's your personal property. You sign that, and the trustees sign it, and it's made a copy, put in the trust documents. You have a Schedule B, which is your real estate. If you have real estate, you have to get the deed. You take the deed, and you're going to go onto a Schedule B of the trust document, put the name of the deed and then you're going to go to the county, and at the county you say, I'm transferring the deed from my name to the name of this trust. And the trustee would have to go with you if you're not a trustee. That's your evidence of transfer. So, and then Schedule C would be a list of beneficiaries. Some banks, especially I noticed in Europe, are now wanting to know who the beneficiaries of the trust are. And so that's just the way they're working. And if you have to give them that, then please do not hesitate. You can always change it later. So you must, whatever documentation is required to fulfill the needs to make this trust operate in a profitable, functioning manner, then just do what's asked as best you can within the limits of what you know is correct. And if you can't hold it, then look for something else. But it's a very powerful document, and most people that get it really, really like it. Okay, next slide, please. Yeah, so now what we've introduced is some people have come to us and they're not looking necessarily to fund their family legacy forever. They just want to set up something really slick, really fast. They have an idea in mind, and it's usually a product or a service. And so what they're going to do is they're going to come in and they're going to alter the trust a little bit differently. And we're going to have the trustee come in. The client is going to come in as a trustee, and he's going to bring his money in, and he's going to get what we call trust certificate units. These are trust certificate units. They're certificates, And the difference between a trust certificate unit and a UBI is on a personal trust, a family trust, usually the client comes in, he has an estate already established, and he wants his children or grandchildren to receive that benefit. And so he would create a trust with just for the UBIs, units of beneficial interest. If you're going to do a business and you're going to fund it yourself, then you might want to consider enlarging it and working with our trust certification unit, certificate units, in which case we alter the trust a little bit differently and allow more flexibility in what it is you want to do. That's the main difference. One is for your family, one is for major business. And it doesn't alter the essence of the trust in any way, it just alters the way it can work and function. Okay, next, please. Prevailing in legal matters. Okay, so I don't have a lot of information here because we don't have a lot of, we have not had a lot of legal affairs with our trust documents. However, how they determine jurisdiction is the domicile. So in other words, people have clients in South America and Europe who are coming and getting a mail stop or a post stop or a friend in the US so that they can domicile in the US. Some countries are not favorable to the trust that we have. So people come here and they start it here and then they can take it back to where they want, or they can use a bank in a different jurisdiction. So jurisdiction is determined by a couple of things, but the main part is the domicile. Now, how do they get that? Beyond that. Okay, so there's three ways that they get that beyond. One is how do they have jurisdiction to have jurisdiction? Well, somebody must have given them consent. So in other words, if you walk into court or if you hire an attorney somehow, or if you've questioned the process that's going on, then you've given them consent to have some jurisdiction. So you might be domiciled in a state that is more rigorous in what you can do. And they may, if you appear to that court at all, they may have jurisdiction because you've showed up or trustees showed up. So you must be really clear on how you respond to any inquiry from a U.S. government agency, any government agency, any fictional corporate agency should be looked on with a great deal of skepticism. Okay, how do you have subject matter jurisdiction? You have minimum contacts. So if you have any kind of contact at all with an essence of what that matter is, then it's possible for the court to have jurisdiction on the equity process. So subject matter, be careful when you get into the contracts, get into your contracts and your contact, because it can claim subject matter jurisdiction if you're involved with any kind of contract like that. For personal and parties to the case, IRS, tax agency. No, you want to, who is that? Need to question any agency, any corporate agency that comes to you. Need to question them and need to question them always in writing, never responding to a verbal process with them. Get it in writing, get them to sign on the penalties of perjury, which is good luck to you doing that. And don't fall for their gruff. Just be strong. Know that it can be defended. So we'll just leave it at that for now. And that's how people get jurisdiction. But if you're clean, if you act in a very prudent way, personal integrity, then probably never going to have a third-party intervention. Okay, presence and conclusion. We got another slide.
No, that's it.
Conclusion. Oh, I must have a conclusion here. I'll bet. I think next time I'll go back, I'm gonna do I'll do a whole slide on UBI and TCU. I think that's an appropriate subject for next week, next month, if you mark that down.
Oh, I
And
totally
remind me,
agree.
that's, okay,
I totally agree. I've got a number of people coming forward to want to use their trust for business. So the TCU would be very interesting for them.
we have it ready. Me and Dominique have a solid draft ready to go.
Yeah. And then when they make their profits in business in their trust capital units, they would want to, of course, apply some of that to their personal expenses and their family, where the UBIs would come in. So, yeah, the interaction between the two would be an interesting topic.
Yes, yeah, and so that's something for you and me and Dominique, maybe to sit down and have a Zoom. So I think that would be really potent, and that trust document is available now. If anybody is in a situation that wants to have that, then let me know, let Tanza know, and we'll just make it. We'll get a second. We'll get the draft ready to go out the door.
So Daryl is asking, one defect does not necessarily invalidate the whole trust, does it?
No, not at all. The only thing that can be done is that if there's a wrong, the wrong can be corrected, but it can't deny the whole trust.
And Daryl's also asking, why can't the trust sign in the name of the trust?
Say that again.
That's what I said. Why can't the trust sign in the name of the trust?
Well, because the trust, you as the trustee are the one that's signing. The trust doesn't sign. You are the trustee. It's in your capacity that you sign, and you're going to sign not as yourself, but as a trustee. And so there's a strength of the trust right there, is that here you are in a fiduciary responsibility capacity, and you're coming in, you're signing as trustee, and it strengthens the whole trust document.
And David is
So
asking, when signing as trustee, do you have to put down the name of the trust? For example, my name as trustee for name of the trust every time?
no, whenever I sign my name on my checks or any correspondence, I just sign my name as trustee.
Yeah, like comma TTE or comma trustee, right?
Sure. Whatever works for you.
Yeah.
If your bank accepts a check, it doesn't matter.
I'm sorry. Say again, Will?
It doesn't matter whether you put trustee or not on the check. If the bank will cash, it doesn't matter.
Right.
If you're
But if you
depositing
sign, if you're signing trust checks as a trustee, then it's really appropriate for you to sign as a trustee. That just keeps a clean record and keeps you on top of the game, that you're aware of how it's working.
well, maybe
You
the
could have the checks can be printed with the word trustee under the signature line. You can have it printed however you want.
Okay. Yeah.
maybe the point Will's bringing up is, are we talking about outgoing checks or incoming checks?
I'm talking about outgoing checks.
Either one.
Right. Okay.
Yeah. But usually it's payments that you would make to others.
Right.
That's where it's more important, probably. Yeah.
In my trust checks, it says ABC Trust, Randall Hill trustee, and then my signature is always just my name and as trustee. It's pretty basic.
Okay. Daniel is asking, if the trust pays a credit card debt of the beneficiary or trustee, what is it considering? Is it taxable?
I don't know. Uh, we want to get into that. I want to wait on that question. Have another one, please.
Yeah, I'll just say, Daniel, that it depends on how the trust minutes are written. If the minutes have authorized the beneficiaries to be compensated or the trustees to be compensated, the trust can be authorized to make those payments. And the taxability depends upon the recipient,
Right.
the recipient's status.
correct. Okay, very good.
Pat is saying, why is trust as sole member of LLC dangerous?
Dangerous?
Why is the trust being the sole member of an LLC dangerous?
I'm not sure it's dangerous. When I was running an LLC, my tax guy told me to put at least 1 or 2% down as a real human being, as a member of that LLC. It had minimal impact on my tax process, but the government was more friendly to the fact that there was a human on the ownership as well as the trust. So now anybody that wants to get an LLC, I say just give, 2%, 5% to yourself or your partner, and 98 to 95% to the trust. And then it's a pass through. So even if LLC, doesn't matter how much money the LLC makes, because it's going to pass through right to the person or to the trust.
Yeah, it's the same principle with corporations. You don't want to give 100% of the corporation's income to the trust because it would raise eyebrows
Right,
and red
right,
flags. Yeah.
right. If you're in a corporation, you're going to have to take the hit with taxes, and you have to put your after-tax dollars in the trust. So you might want to consider that. And maybe, Will, you've got some information, but
Well,
right,
any type of corporation or LLC is a taxpayer.
right,
Okay. When you're choosing to use that vehicle, you're choosing to be a taxpayer, or at least that entity is choosing to be a taxpayer. So you're going to be subject to whatever their tax law is in that state or jurisdiction. So I would say just choose carefully.
yep, very good.
So Ashok is asking, if one is domiciled in a certain state and wants to have an address of a different state, say for example, Nevada, for the trust, how would one go about it? And having a PO box acceptable, or should one have a physical address?
You can do both. I have clients that take their mail at their house. Their domicile is in their house. They have a family trust. They don't need anything else. I have people that have businesses and they have mail stop in whatever state is fluid for them. I choose Nevada. It's one of the better privacy states for any any statutory entity. But it doesn't matter. The idea is that the domicile can be changed. The where you get your mail or where you get your full-on mail. If you're connected with the government, they might want to have an address that you're going to receive. They request that. Just have something that's efficient for you. It doesn't really matter whether it comes to your home or your business or to a mail stop.
Pat is asking, if a beneficiary is hired by the trust for any kind of service to the trust, then is compensation not taxable as a distribution?
No, if he's working for the trust and he's paying 1040 filing taxes, then he's got to be responsible for that money. It can't be on the trust. So the trust is a pass-through, and it's giving that person, paying that person a salary for the work that he does. It doesn't have anything to do with his beneficial interest. His beneficial interest is coming from a different place, a different part of the trust. And depending on what position he is with his tax liability, he may have to pay tax on that as well. So the beneficiary is responsible for any taxes that may be on what he receives from the trust. And it's up to him to get his tax process straight.
Okay, Donna is asking that you mentioned a trust book earlier in this session today.
Twice.
Weiss. It's Weiss is concise. Didn't I ask you to post the link? Don't we have it somewhere?
Okay.
Carlton Weiss.
Yeah, no, I haven't posted it, but thank you. Let's see, maybe during the webinar, I can put it into chat. How do you spell that?
WEISS, Concise Trustee Handbook.
Okay.
I think I sent you the link. If you can post it, it'd be great. But that's the, he's really dialed it back. He's kind of opened the book. He says, look, these things are basically impenetrable if done right. So get out of your corporate head and think about a natural law trust, or whatever you want to call it, but have that contract in your hand so that you know what you're doing and you can step up to the plate and be really strong in how you make your estate work.
Right. Ashok is asking, the corporations and LLCs are now being mandated by the government in the name of the Corporate Transparency Act to disclose beneficial ownership as a reporting requirement, at least with an NLT. Is this not necessary? Is this correct? And Randall, you sent the link about how the Supreme Court overturned that ruling, right?
Right.
So it's
They
not
did.
even,
They said, can't do it. You know, it's like, it's not appropriate. So it's, you don't have the right to have that, to go in and force you to do it, especially for a trust. You know, they can force the corporate structure to divvy up and give them what they want, but the trust veil is really difficult to pierce unless there's been a major corruption.
yeah, the trust is
Breach of trust.
non-statutory, so it's not subject to those statutes,
That's
even if
right.
it was enforceable against the corporations.
Right. See, the state is required to enforce anything around corporation or LLC, any corporate entity. The state is enforced to do that. In fact, that's why you have, if you have a 501 C3, that the state can step in and say, you can't say that in front of your pulpit or whatever. Or do we have a 508? See the difference between a 501 and a 508. 508 is totally, it's an exception to the rule. It has not, it doesn't have to file it. They can't even inquire into your church as a 508 if you set it up properly. So again, you set your trust up, you set your corp soul up, you set any corporate entity up the way they want it, but always have it as a pass-through going to your private side. This is the whole thing about commerce where I started. Commerce is in the public. What we want to do is make your public face presentable and equitable and really thriving, and bring it back with minimal debris falling off its side to your family trust where that estate can grow as a legacy. It's very, very powerful process. So we have here between the paperwork we have on establishing your identity as a sovereign, the use of a trust, the use of the knowing how to pass through entities, use those entities to serve you. It's a very powerful process. So you've come to the right place.
Reggie is asking, how would it work if the owner of the LLC has done the revocation of election process?
Has or has not?
Has.
Then the LLC is a pass-through. So if it passes through, if you're the sole member of the LLC, then it could go to you. And if you've done your ROE, then you're out. Wouldn't matter.
So Daniel's saying if the trustee gets paid in crypto, there is no paperwork. So what kind of filing should I submit to the IRS at the end of the year?
Or file anything. Crypto is not a filing requirement. Crypto, there's no profit in crypto. All it is trading little coins. I mean, if you take your crypto and you buy a house with it, now you're having to put your house in trust. Otherwise, you might get taxed on it. So it depends on how you take that crypto and what you use it for and how you spend it, whether it becomes a taxable burden or whether it's just a pass through.
No, the title of ownership of it is transferred to the trust, then there's no reporting on that.
Correct.
It also depends on whether the individual is a taxpayer at all.
That's correct.
What is your current status?
Right.
Because there are some people that are not taxpayers, yet they
Correct.
reside within the country. So you got to be careful about that.
That's the whole thing. It's like We have these three things. We have these entities, these corporate entities that allow us to do function really well in the corporate public structure. And then we have the ability to have private and on our own side of the lake. And we just have to be really clean and knowledgeable on how we do that. And the work that we've done here and what I can do and help people along the way, reading these manuals are important. And it's pretty simple. Once it's done, it's done. Because once you've established your process and you have it intact and it's running, then you're out of the loop, basically. That's
Dr.
where you want
Which-
to be.
I'm just curious, so on the Weiss handbook, which version or which do you
I have the
recommend?
long one. My notes today came off his long one. It's a Moorish link. I gave you, I think there were two of them.
Okay.
they're
And
both-
Taunton, you put that in the chat?
I have to stop the screen sharing to do that.
Oh, okay. Never
but
mind. I was just curious which one it was.
I can get a minute here sometime during our show and do that. So,
You could also send out an email later. We could post those.
yeah.
Why don't we post a bibliography again? You could send out maybe a post.
I'll tell you
Tons.
what, I was thinking of sending out a newsletter to the activated trust operators about the Fidelity bank account solution. I could add the bibliography and the Weiss information into that.
Great, good idea.
Yeah.
Very good idea.
Dr. Pamela was asking, if I can find it again. How will Jasara Nasara affect the tax structure of the trust, as all taxes but luxury tax on new purchases should be abolished by Nasara?
Let me put my great wisdom hat on here and tell you about the future. I don't know. Who knows?
I don't think that's a question that can be answered until
I
it's
don't think
done.
so either. But that's a good question to lighten up this load here.
Well, Jasara Nasara eliminates income tax anyway.
All right, it's going to change everything
It'll change everything
Yeah.
for everybody.
for everybody.
They're talking about having a tax on purchases. We'll see.
What
Yeah.
doesn't matter? It won't matter because if it's an excise tax, now that's the legal. The government has a right to tax if it's apportioned correctly, right? That's the whole Constitution. If it's apportioned respectively, then it's okay. It's just when it gets, oh, we're going to charge you more than the next person, then that's fine. I mean, the typical in the old days, you gave 10% of your crop to the Lord because that was the tithing. You gave it to the church, or you gave it to the Lord, or you give it to the IRS. You give 10%. Okay, if you know that you're going to work all your life and you're going to give 10% tithing, whether it goes to all three, you don't have to give it all
Done
to.
speaking.
I'm sorry. Then you've got it. You've set it up. You're in that forward movement of life. And when you get your financial and your trust assets in an estate and get it all ready, you're good to go.
So Margie has posted the Weiss Trustee Handbook link into the chat. So thank you, Margie.
Thank you.
Pat is asking if BOI reporting of LLC involves trust, are trustees required to be revealed or just the name of the trust?
Just say the name of the trust and you as trustee. It depends on what they want.
Right.
But you're signing now. You always sign as trustee. Doesn't matter whether the trust name is on it, but any document you sign for the trust as trustee, you sign it as trustee.
May I ask a question?
Sure.
Yes, hi, JB.
Oh. Hi. I wasn't, this is a new system, so I wasn't sure how this works. And it kept, exiting me, so I really didn't know. If
Well,
you're under this,
it's best to raise your hand first. That's how you get acknowledged.
I tried that way. I didn't find it.
Oh,
So in my system on my phone. So
okay.
anyway, sorry about that. If you have Nasara announced and your system is now under the QFS, where the funds go directly into the QFS, where they're safe and protected, and you only need a trust when you exit the QFS for a percentage where you want to set up some funds with the bank. You want to have a relationship with a bank. We don't really know which banks are going to survive. But when you have that relationship with a bank, you can move some of those funds into the bank where you can set up the trust. Is that correct? Other than that, your QFS funds, which is the majority, which is your mother load, will be protected and safe where you don't need a trust there. Is that correct? Can you enlighten me on that, please?
Well, I think it's pretty online. I think funds in the QFS will stay there. They'll be protected because it's gonna be in a vault, basically. And you, as a client, are gonna be able to take certain parts of it out, all of it, or whatever you feel is appropriate. But in the QFS, it'll be protected, and the only thing you need protection for is when you take out a sum and you want to do something with it, are you going to make sure that whatever you trade that money for is going to be protected? So if you buy a house, then you want to have the house in a trust, etc., and just goes on from there. So that's what you're looking at. You're looking at a trust to protect that part of the asset, that part of the asset that you pull out of the QFS.
Oh, that's wonderful. Thank you so much. Could you, Randall, could you enlighten me on what tricks, maybe Will can do that, but what tricks of the bank in the old system that they may pull on you when you're setting up a trust and their demands for certain requirements? Is there there's supposed to be a significant change over, and we really don't know what they're going to be in terms of the new system and how they're going to orient people. There's no tax. I don't know if there's going to be any suits because we'll be moving into common law and measuring injuries solely. So I'm not sure how, have there been any revisions to your trust, Randall, that may encapsulate or encompass some of the new system changes that we're going to
Yes,
be
yes,
going through?
absolutely.
So
Gabby, thank you. Thank you for that question. That was really good. Yeah, I think when the QFS comes, there's going to be a whole change. So I think that there's no tricks in creating this document. You just have to go into the bank and ask for, you say, I want to set up a banking account for this trust, and that's all there is. And whether it's because of QFS or because it's your business or because it's your family estate, it doesn't really matter. You're going to create a relationship with a banker. Hopefully the bankers will become more prone to working with our trust. Tanzan has had good experience with that this week. And so we just keep moving on. And there's really no tricks, Jabby. You just have to, be conscious of when you go into the bank and what you ask for.
Well, I would just thank you. I was just thinking of the tricks coming from the bank based on their 3D system and their orientation to what they've done for their history. And now it's all going to change. So how they accept us as the new wealth is something that they may not be amenable to. So I was just trying to, there's a lot of changes, and does how
I
does
don't
one?
think you're going to have to worry about a change. If you have one of these trusts now and it's working,
Yeah.
it's still going to work in the new system. The QFS is interesting in that you can actually hold digital assets in the digital domain on that system. So the trust may have assets that are representative with tokens. So those could be held digitally versus the physical form. But in terms of how the trust works or the law itself, I don't think you'll see much change in that
Okay.
regard.
Yeah, I
Okay,
don't,
because I went to Wells Fargo to set up the trust. This goes back years ago, and they denied me because I didn't have a tax identification number, and they also
course.
wanted to keep the Social Security trustee with the Social Security number, and I absolutely refused to put that identifier with the name. So I had an EIN instead for both the trustee and the trust, and they just wouldn't do it. So that's the old system. I'm just wondering if Social Security numbers are going to be obsolete and more
Idea.
accepting. I'm
I'll
sorry.
put on my hat again. Oh, I see great changes coming and we'll all be surprised.
I just don't. Okay, these are just
It's a
some of the things.
surprise. It's a surprise.
Okay, all right. Well, thank you so much for those answers. I appreciate it, and thanks, Will, as well.
I would just
Thank
say
Welcome.
All right, Jeffy.
your social security number is your vehicle in commerce. As long as you have documented yourself as being distinguished from the straw man, you're fine. You're a sovereign and you can use the SSN as your vehicle in commerce.
Right.
But
Good
I
point.
don't have it in all caps. You see, my
That's your
trust,
vehicle in commerce. That's your vehicle in
my
commerce. That's not,
Right.
but my trustee is not is the living woman
that's right.
as trustee, and
That's
so
right.
you can't connect a Social Security commercial entity
Yes,
with a living
yes, you can.
woman.
Yes, you can, because that number doesn't
This is not
represent you.
good.
They don't really care. The clerks at the banks don't really care. Where it matters is behind the scenes in the government databases. So you can provide your SSN as trustee, and that fulfills the bank's purposes. Behind the scenes in the government databases, if you've documented yourself through the ROE correctly, you are distinguished from that number and from that vehicle.
But why ask for it at all then? If you're distinguished it
Because
from
you're
it,
using it as your vehicle in commerce. I've said that 5 times.
Yeah. That was actually a good response, Taunton. I think that's probably the most appropriate one.
You
I'll
need
tell
to
you from the
understand
bank's
what I'm saying.
perspective.
It's your
what-
vehicle in commerce. So use that number as your vehicle in commerce.
Right.
but can't an EIN be a vehicle in commerce as well?
No,
That's for the
because
trust. That's not for an
that's for the
individual.
trust.
No. I'm
Right.
talking about identifying the trustee with an EIN
No,
instead
no,
of a
no, no,
Social
no.
Security
They,
number.
No,
Well, I'll
no.
tell you from a
You're
bank's
not understanding
perspective,
what I'm saying. So
What-
go
I'm
ahead.
what a
understanding
bank-
it perfectly. Listen to what Will has to say.
what a bank wants to see is 2 things. They want a social security number associated with a signature. If you're working with a bank that you've already had a relationship with for 20 plus years or whatever, it doesn't matter, but you go in to get an account for one of these trusts, they'll ask you for the EIN for the trust, and they won't even ask you for your number because they have it already.
Right.
They'll just
Exactly.
say, oh, I've already got
Yeah.
a signature thing on you, but we'll do another signature card just for the trust. But they're not worried because they already know who you are. The way the bank system is, it's just an identifier to them. And the people working at the bank, they don't know any of this. They are clueless. They're clueless idiots. Okay. That's the situation. All they know is their computer demands a number gets in there or they can't go to the next screen. That's all they know. And
But Will,
so there's not any really, look, as the trustee, you're signing on behalf of the trust, not yourself. It doesn't matter if you share a social security number as a signatory. It's the trust that is important in that capacity.
But when you
So
registered with the bank 20 years ago, you put the all cap name with the family name attached to the social. Now, as you enlighten yourself and take courses and wake up, you're let's say I'm like Janet Linda for the trust. Okay, so I'm the living upper lower case, no longer tagged with the Social Security, but they say since you opened up the account with the all cap name, the full all cap name, including the surname, the family name, That's what we've tagged it with, but that's not me anymore. That I'm upper lowercase as
Go
a
to a
It
different
doesn't
trustee.
bank.
matter. It doesn't matter to the bank. There's
It
just,
doesn't.
there's a form to be filled out. And if they don't fill it out, it can't go to the next screen. So
Okay.
So,
you're talking to people that don't know anything about this.
Okay. All right then.
So
Well,
if you
thank
want
you
to
so much.
function with a bank account, with a trust account, the account is for the trust. And it doesn't matter that you have a social security number associated with the signature card. Everything you do is on behalf of the trust. It's not going to reflect on you personally.
Okay. Thank you so much.
You're
Thank you
welcome.
all so
You're
much.
welcome.
Thank you, Tanzan, for explaining that
Jamie.
5 times.
You're welcome. And that's not where your status is determined. It's not determined at the bank. It's determined by your documentation with the government.
Right.
Yeah. So Pat is saying, if a trust operates a business directly, would it be prudent to create a manager relationship with the trust in order to sign as manager rather than as trustee?
No, if you're trustee, you just sign as trustee. You don't need to be a manager. A trustee is more important position than a manager. Because as trustee, you have lawful and legal title to all the property in the trust.
I would call you managing trustee.
Well, I call them executive trustee, so
Executive
it
trustee.
depends.
Yeah.
I just say trustee, and then you fill it in however you want. First, second, third, fourth, fifth.
Yeah.
It can be really easy to overcomplicate this stuff because that's how their system works. That's how the corporate world works.
Yes.
Is complex structures. We don't need that. We just don't need it here.
Thank you. Well said. I'm all for simplifying. Absolutely. Well, while we're waiting for any more questions, Randall, I have a point. I was wondering if what you think of possibly doing a webinar on the clauses. I don't think we've ever done one where you've maybe touched on one or two, but you have. This is something I've been boasting about on your behalf, is that you have, some people collect gold coins, some people collect stamps, you collect clauses. And you've got the greatest combination of clauses, and thanks to Dominique for really bringing that to our attention. The greatest collection of clauses of any trust in the world that maximizes the freedom of the trustee and the asset protection for the beneficiaries. What do you think of doing a webinar on the clauses and what they mean and what their significance is and how rare that is? And as far as we know, it's that
Let's
combination
do
is
it next month.
not present in any other trust. Yeah.
Next month, let's do it. We'll do it next time. And if you want to start it, if you want to come in a week early, Will, and do an aspect of it, you're more than welcome. We do it together, or I'll join you, or you join us.
We could do that. I in terms of, I kind of like differentiating between the trust units versus
Okay, that's
UBI.
fine.
I think that is an important designation because these trust vehicles could be used for anything. They could just be a holding thing that holds an asset, or
Yep.
it could be a fully operational business. And there is flexibility to do some portions of both. But when you get into complex structures of businesses and assets and everything else, you might be getting in a situation where multiple trusts are actually needed to best suit the need. So it just depends. But yeah, let's talk about it. That's in May, right? Middle of May.
Mid-May, 15th, I think.
Yes.
Yeah.
We've already
Yeah,
got
Yeah.
comments in chat coming in saying, yes, they would love a webinar on that topic.
Okay, it's going to be a done deal. Be a good way to go into the summer weather. We'll understand totally about clauses, and then we can go eat lobster claws on the beach in the summer.
And the other comment in chat is really interested in hearing the difference between the UBIs and the TCUs.
Well, I think that it's going to be part of what we're going to do next month.
Okay.
Clauses and UBIs and TCUs. That's a good title. Clauses, UBIs, and TCUs, or any interpretation of the said kind. It's your title, Tanzan.
Okay.
Make
Uh,
it colorful like you always do.
Those are all the questions that have come in so far. Will, do you want to say anything like any just a nutshell update on news or?
Just a couple of things. And I run into this in the banking world. There are thousands of these types of trusts out there, and the uber wealthy have been using them for years. If you think the Rockefellers and all these Kennedys and others are paying a bunch of income tax, you would be wrong. They don't touch a taxable system, not with real wealth. And you're now learning, you're getting opportunity to learn about how you don't have to be a part of that system anyway. The interesting thing about the current tax system is Congress has always referred to it as voluntary. Why is it voluntary? Well, probably because the IRS is domiciled in Puerto Rico. It was never created with an act of Congress. The 16th Amendment was only ratified by, I think, 2 states. So we have a whole fiction playing out here. And the only reason that they're able to get away with bullying the people, because they use force, it's the intimidation of real violence. Pay up or we come at you with the guns or the jail or whatever, right? Why did that occur? Well, it occurred because the politicians that could have put a stop to that, they got a little bit added to their bank account. So they allowed them to do that, right? So we've had 100 years of what I would call rape and pillage, okay, by these people that are not even within one of the sovereign states of the Union. So that's why I said when it comes to jurisdictions, choose wisely. A lot of people don't know this, but in 1968, when they corporatized the post office, they came out with this new fancy thing called zip codes. And then they told everybody that with a zip code, your mail's going to get there faster. Well, it doesn't get there any faster. Why the zip codes? Because all the zip codes are owned by Washington, D.C., and not by the state in which you reside. So you use a zip code, you're just admitting, oh, I'm a resident of Washington, D.C., therefore I'm a taxpayer. Okay. So when you learn these things, you start figuring out, oh my gosh, I actually went along with the system, but I didn't know. It's okay. Give yourself a break. You didn't know, but now you're learning now, and the system's about to be abolished anyway. So things are going to be very different. Even by the time we get to May, the middle of May, things might look a little different. Okay. We'll see how that goes. But I just want to encourage all of you, you're in the right place. This is the vehicle, no matter what happens over the next 60 days, will still get you where you want to go and will protect your assets along the way and take care of your family. And I know a lot of people that have been using these for a very long time, and they're very successful. So just my hat's off to Randall and Tonson for all the work you do. Try to educate the public that there is another way to live, and it's better. Thank you.
Thank you, Will. Catherine, you've raised your hand. Would you like to say?
Yes. Yes. Hello to everyone, and thank you for a lovely seminar. I've enjoyed all of these, and I look very forward to your one in May, Randall, if not before. I just wanted to ask a question, a point of clarification. Many of us have been studying on our own, really anything we can find about the upcoming QFS and how it will affect all of us. Will the QFS, which I would just call a vault, will there be accounts in there that are not for individuals? For instance, we would all have one under our individual name or identity, but could we have one in there under the name of a trust, a partnership, or some other type of entity? That I have not read about, and I wondered if any of you knew the answer to that.
I'm told the system does facilitate for businesses and other entities like trusts. So it will be, you'll find this out when you go there personally, about how that works. I'll think about it logically. If you move to a brand new system where everybody's got to be on it, why wouldn't it accommodate that?
Right.
It would. They're gonna have a facility for that because the whole world runs around business. That's how
Right.
commerce has moved. So I wouldn't stress about it. It's going to be fairly easy. I also think things are going to change with the banks because any of the banks that are still left standing after the dust settles are going to be begging you for business. I promise you.
Right. So if that is the case, Will, we've heard recently in the last week or two, an individual going into a bank, which I guess would now be more of a wealth advisor, perhaps acting as agents for U.S. Treasury, to convert some assets into the new currency. They have said you would have 10 days to get a trust. Well, maybe is it better to have a trust first such that the majority of a trust funds can be in the QFS under the trust versus and just bring them out piecemeal, little bit by little bit, into the banking entity. Do you see what I'm saying?
No.
Yes,
I
do it as
don't,
soon
that's
as you
too
can.
that's too complex. I think you just have the QFS and they're gonna pay your trust, then you take it into your personal realm. But I think it's too complex to think about trying to have the QFS give you or direct you. This is the whole thing, this is my conclusion. When we finish this, I want to read this last little paragraph. The idea is we're going to educate you, so it doesn't matter what they do in the end. When it happens, you'll have the education through what we're going to do for the next couple of months in our seminars. You'll know how to handle the situation.
And Pat has pointed out in chat that you could transfer your assets to the trust via a minute. So if you get your assets in the exchange in your personal name, all you have to do is do an assignment or a transfer to
Right.
the trust.
Yep.
If you've
So let
already
me-
done the trust work and created it so that you have a trust, okay, you're not waiting for that. It's going to be very easy for you to do that. A trustee can bring assets in as
Right.
well as a grantor or other people. So there's the ability to get it there if you have already created it. If you're
And do
waiting
it
till
now.
last minute and then they're telling you, oh, you got to have it done in 10 days. Oh, poor Randall might be busy.
Well, if we get it now, this is the whole thing. This Tanzan has given everybody a chance to do it. If you don't have a $2,500 and you need to have something, you can do it on a payment plan. And if you have that payment plan, then you have the elements of the beginning of a trust in your hand before the RV happens. So if nothing else, at least get a prototype in your hand that you've got the trust, you've got the name, you've got an EIN number, and you're ready to go forward.
Okay, thank you.
So let me just say, the bottom line is that the natural law trust relation is the most flexible means to owning nothing and controlling everything. And when utilized shrewdly, affords its participants with all the ingredients to live well naturally. It's also true that no matter how many arguments are made against our trust, the learned reader will always hear the propaganda and the spin, knowing from his own knowledge and independent study of our trust, in reality, can only fail due to some misgiving or inappropriate on the part of a trustee. The trustee must also trust himself. So that's it. Simple paragraph.
May I?
Sure.
That was excellent, Randall. I had just a comment and a question. The comment was that what they said about having a trust prior to the exchange or the redemption is bogus. You don't need it. Once they will orient you, and if, like you said if you have a trust already, then they'll work with you. If you don't, then they'll create this temporary situation for you that will last 90 days. But not to worry and not to get stressed out, and just follow the flow. The other
Yep.
thing is, I wanted to know, I was told that we will not be dealing in commerce, but we will be dealing in trade, which is more for the sovereign and more in the common law. So can any of you explain the differences, and is that correct? Commerce is mainly for the corporation that will exist, where attorneys, however small, and we hope very small, will have a function to represent the corp, but we will no longer be a corporation. We will no longer reside in DC. And so as sovereigns and returning to common law and constitutional law and natural law, we will be dealing exclusively in trade. So can any of you explain the differences, and does that make sense? And I yield.
Yes. Commerce is public. Trade is private. Really simple. I go to the flower market and I trade something for something. That's a trade. If I'm out in public going to a bank or going to the supermarket, I'm in commerce. If I'm selling my product out in public, I'm out in public. I'm in commerce. If I'm just going to the farmer's market to trade some coconuts for some bananas, which we do here in Kauai, then that's all it is. It's a trade. So I think that simplifies it. I don't know if that serves you, but Will, maybe you can add in something.
But if the banks are in common law, because they're going to be dealing with asset-backed United States notes and gold currency throughout the world,
Yeah,
will they be in the public domain?
sure.
Will they
You're
all
still
be dealing in trade because of their gold asset-backed system?
It doesn't matter. You're still dealing with the public. When you step out of your front door, you're dealing with the public. You have to get in a car or a bus to go somewhere. It's all just switch from your house is private. When you go outside the door, you're operating public. And if you can take this trust and know the ramifications of it and how it works, then you can take it freely anywhere, and you can use it in commerce or you can use it in trade.
Okay. Thank you.
That's
I
an
mean, Will,
excellent
if you want
answer.
to add to that, or Townsend.
That's a very
No,
excellent answer.
you did a
Totally.
wonderful job. There's nothing more I can add. Great.
Yeah, that's perfect. It's just that the public system people distrust because it's been corrupted. But that's changing, and that's what Will's been reporting on, is the positive changes in the public sector. So as that gets transformed, the public will be just as safe as the private.
Right, right. I'd agree.
Wonderful. Thank you so much.
Thank you, JB.
Good to have you, Jemmy.
Miss you, Randall.
Yeah.
Okay,
back.
everyone. Anything else? Anyone? So I guess we'll wrap it up. Thank you, Randall. Thank you, Will. Thank you all who attended. We have March 20th today, May 15th, 2024 is the next one, 2 months from now. And it looks like we have some good ideas for topics to focus on then. All right,
That's
so
right.
door to a new time is opening for you.
Yes.
Make it a good one.
All right, we're in a good flow, Townsend.
Thank you, everyone. Aloha, Randall.
Aloha to everybody. Thank you very much.
Blessings, Will, and blessings to
See everyone.
joined us.
Aloha. Thank you.
Aloha.